Professor Barza, thank you very much for your kind words. So I'm on a PhD student on a third year now, and my dissertation will deal with the influence of EU on substantive family law on institutes of marriage and parental responsibility, and in that way also on children's rights. So my hypothesis will actually be that EU through soft law instruments and also through case law of the Court of Justice kind of starts to shape the substantive family law of member states. For example, I will deal with cases Koman and others versus Romania and Pancharevo case, which involves Bulgaria. There is also a case that concerns Poland. There is Rzecznik Prawo Obywatelskie that was, passed after the case Pancharevo. Now there is also a case that is currently before the Court of EU that actually will be like a next step of Koman. So I will focus on this, and at the end of let's say last part of my dissertation, I will try to see how these cases, Koman and Pancharevo, for example, would work in countries such as Croatia, such as Hungary, and also Italy. And that's why today I chose to talk about Italian family law and changes that occurred in Italy and institutes of children's rights and parental responsibility. Last year, I organized a panel with a similar title, and I spoke about Croatian family law. This year, I chose to speak about Italy, because first of all, I couldn't find anyone from Italy, so it was very difficult, to be honest. And second, I mean, it's connected with my topic and very interesting and challenging for me, so I think I did a good choice. But please take into account that I'm not an expert in this. I'm still new, so yeah. And if it's okay, I could start with my presentation now. So as I said, today I will talk about children's rights and parental responsibility, what is new in Italian family law. So in Italy, parental responsibility is referred to as responsabilità genitoriale, and actually it is defined as a set of rights and duties of the parent of the child for caring or for protecting the unemancipated child who is presumed not to be capable or able to take care of his or her own interests. And unlike, for example, in Croatia, where it is regulated under Family Act, or for example, in Poland, it is regulated under Family and Guardianship Code. I think in Bulgaria, it's also Family Code. In Italy, it is regulated under Civil Code in the first book, which is about the persons and about the family. In the chapter number 9, which is specifically about the rights and duties of the child and also parental responsibility. Prior to 2013, actually, Italian family law didn't use this term responsabilità genitoriale or parental responsibility, but actually it used term potestà dei genitori, which can be translated as parental authority or parental power. Now the question is, what is the content actually of parental responsibility? So again, unlike, for example, in Croatian Family Act, where there is article titled the content of parental responsibility, for example, in Italy, there are many different provisions from which we can actually infer the content of this institute. So, for example, Article 315, rights and duties of the child. Child has a right to be instructed, educated, maintained, and morally assisted by his parents with respect, of course, to his or her abilities, natural inclinations, and aspirations. Child has a right to grow up in a family, to maintain meaningful relationships with his relatives, which means it is the duty of his or her parents to provide education, instruction, maintenance, assistance, and also a family for a child, and to maintain relationships with the child. Also, when it comes to duties of the spouses, Article 147 towards children, It is their duty to maintain, to instruct, to educate, and morally support their children, of course, with respect for child's abilities, aspirations, and natural inclinations. Also, Article 316, parental responsibility. In paragraph 1, it is prescribed that parents, by mutual agreements, actually establish or determine habitual residence of their child, and also representation and administration, because they legally represent born or unborn, even unborn child in all civil acts, and administer child's property. So to sum up, parental responsibility includes rights and duties of child's parents to instruct, to educate, to maintain or support child, morally assist child, determine child's habitual residence, maintain personal relationships with the child, legally represent the child, and administer child's property. The question is, who has parental responsibility in Italian family law? So when we take a look at Article 316 of the Civil Code, both parents have parental responsibility, which is exercised jointly, again, taking into account aspiration, natural inclinations, and abilities of the child. If child is born outside of the wedlock, then the parent who recognizes the child has parental responsibility. And if both recognize, then both have parental responsibility. So the answer to this question would be parents, biological or adoptive, according to Civil Code. Now the question is, who can adopt the child in Italy? So according to law from 1983, Article 6, only spouses can adopt the child who have been married for 3 years, and there shall be no personal separation between them in the present, but also in the past, not even de facto personal separation. So that means that actually single individuals are excluded, and also the question is what with same-sex couples, whether there is a possibility for them. So whether they can fall under the term spouses in this sense, the answer would be no, because if we take a look at the constitution, there is no definition of marriage. In Croatia, for example, there is. There is also no definition of marriage in a civil code. But the civil code refers to spouses as marito e moglie, which is husband and wife. So it would mean that marriage is only for heterosexual couple. And when it comes to same-sex couples, there is a special act from 2016, according to which they can enter in civil unions, and they are excluded from the possibility of adoption in this way. However, it happens that, for example, single individual goes abroad, or, for example, it can happen that a same-sex couple goes abroad and comes back to Italy. So in this case, this is judgment by the Constitutional Court, in which actually a single unmarried woman applied before the family court in Florence. And she actually requested reproval for inter-country adoption, and she was denied. And then this lower court actually turned to Constitutional Court, posed the question of constitutionality, arguing that actually it is not in accordance with Constitution, that this provision, Article 29 bis 1, actually violates Italian Constitution, violates the best interest of the child, violates Article 8 of the European Convention on Human Rights, the right to respect for private life. And what happened actually is that this contested a legal framework, this Article 29 bis 1 of law from 1983, actually states that unmarried individuals that are residing in Italy, they are not able to get approval for inter-country adoption. And the Constitutional Court said that this provision is not in accordance with Constitution, and that it violates Articles 2 and 17 of Italian Constitution, Article 8 of European Convention on Human Rights. And it actually stated that there should, that the freedom to choose parenthood actually is not absolute, and that best interest of the child needs to be taken into account and actually needs to be balanced with it. Also, there was a case also from 2025 where one woman who is in a same-sex couple, and she actually applied to get to be granted to use this mandatory paternal leave. So she was in a same-sex couple, and they have a child together, and she applied to use this paternal leave. However, she was denied, and she was registered as a parent in a civil status records. So she was denied. According to Article 27 bis of this Act from 2001, which actually grants only fathers to use this paternal, mandatory paternal leave of 10 days, fully paid, within first 5 months of the child's life. So the Constitutional Court said that this article is not in accordance with Constitution, that it is unconstitutional. Why? Because it stated that she is intended, she is mother, even though not biological, but intended mother of the child, and she is registered as a parent in a civil status records. So she should have the right to use this paternal leave. So we can see that court put focus more on affection and the bond that existed between two mothers and the child, and not on a biological relationship. And in this second case, it happened that the same-sex couple actually went abroad. Their child was born in Italy. They came back to Italy, but they went abroad for medically assisted reproduction. And the problem was for intentional mother. How shall her status be recognized? Shall she be recognized as a parent of the child? And when it comes to medically assisted reproduction in Italy, it is only allowed to couples, heterosexual couples. So it means those that are in marriage or in cohabitation, so not to single individuals, not to same-sex couples. The contested legal framework was Article 8, which says that child born from medically assisted reproduction shall have the same status as child born in wedlock or child born outside of the wedlock whose parents recognize the child and express their will to use these techniques. So the court stated that this article is not in accordance with the Constitution, and that actually it is discriminatory to deny this mother to be recognized as intentional mother of the child who was born in Italy through this medically assisted reproduction that was performed outside of the country. And the last thing I would like to mention is surrogacy, prohibition of surrogacy, or how it is called in Italy or referred to in Italy, vomb for rent. So surrogacy is prohibited in Italy since 2004. Any act, so anyone who in any form actually either carries out or advertises or organizes the commercialization of gametes or embryos or, for example, or surrogacy shall be punished with imprisonment from 3 months to 2 years, with a fine from 600,000 euros to 1 million euros. And in 2024, this provision was amended in a way that now it not only criminalizes Italian citizens who decide for surrogacy or conclude arrangements in Italy, but also abroad, making it as a universal crime. When it comes to surrogacy in Italy, there are two, let's say, opposite views. One, for example, from Catholic Church, who is opposing surrogacy, stating that actually it is undermining institutes of marriage and family, and the other from feminists who are divided into two groups, and one of them are saying that it is in accordance with women's reproductive rights, so they can choose whether they want to become surrogate mothers or not. And the others who say that surrogacy is a way of exploiting women, especially those from lower social economical classes. So debate is still ongoing. And that would be it from me. Thank you very much.